Good afternoon, everyone. Happy Fair Housing Month. Welcome to our virtual resource workshop for housing providers. My name is Victoria Villapando, and I am the Director of Public Affairs at the Illinois Department of Human Rights, or IDHR. Today, I will be your host. For those who are new to IDHR's social media accounts, we are a state agency that enforces the Illinois Human Rights Act. This law prohibits discrimination in the areas of employment, fair housing, public accommodations, and financial credit. With over 19 protected classes under our jurisdiction, including mental and physical disability, disability by association, and source of income, our role as a law enforcement agency is to 1, conduct fair and neutral investigations of discrimination, and 2, determine if a complaint has substantial evidence. If we find substantial evidence, the complaint then moves to the Illinois Human Rights Commission, who plays a different but equally vital role in the enforcement of civil rights. The Commission is a separate state agency that conducts public hearings. More importantly, our collaboration allows people who've experienced discrimination to be made whole, and I want to uplift the commissioners who are watching this broadcast. We could not do this work without you. Thank you. Over the past 4 years, IDHR has worked with the General Assembly and the Pritzker administration to enhance disability protections under state law. As a person with a hearing disability, I would like to personally thank Governor Pritzker, Director Bennett, and Deputy Director Bautista for their courageous leadership. Because of your vision and ongoing support, Illinois is a more just and equitable state for people with disabilities. And that brings us to today's topic, reasonable accommodations and modifications in housing. IDHR co-published a guidebook with Access Living that provides general legal guidance to housing providers. Given that disability-related complaints account for half of the housing complaints we receive, we will highlight this guidance today. If you want to read the full guidance, please scan the QR code above. Before we kick off the program and introduce the governor, I have a couple of logistical notes. First, this session is being recorded. You will be able to replay the recording after the event concludes. If you can, please share this link with your network. Second, please put your questions in the comments section below. We will hold space for Q&A near the end of the program. And now, it is my honor and privilege to welcome Governor J.B. Pritzker.
Hello, everyone. Governor J.B. Pritzker here. Access to fair housing ensures that Illinoisans have a fair opportunity to live, work, and go to school in the communities of their choice. That's why housing is a top priority for my administration, and I'm committed to expanding access throughout the state. Last year, I signed HB 2775 to amend the Illinois Human Rights Act and improve housing protections for all. Thanks to this law, people with disabilities, as well as members of other vulnerable communities, can no longer be denied housing for having non-employment income, like disability payments or Section 8 vouchers. In honor of Fair Housing Month, I'm proud to recognize the Illinois Department of Human Rights Virtual Resource Workshop for Housing Providers. During this workshop, government and industry leaders will discuss housing protections for people with disabilities and outline best practices. Thanks to all of you for joining in today. I want to recognize the incredible staff at the department and the Illinois Human Rights Commission. I have immense pride and gratitude in your work to protect people from discrimination across the state.
Sorry, I was on mute. Thank you, Governor Pritzker, for your thoughtful remarks. Federal and state housing laws allow Illinoisans to enjoy the full use of their homes without unlawful discrimination. And now I would like to introduce Director Jim Bennett. Over the last 4 years, he has ensured that IDHR continues to play a critical role in standing up for those who experience discrimination. And today, he will highlight the leadership role we have taken to pass legislation that expands fair housing protections. Director Bennett?
Thanks. Thank you. I'm very excited to be virtually joining everyone today. I want to thank the members of my team, Victoria, who you've already met, and Stephen Monroy, the Director of Housing, who've been doing the heavy lifting both in the work itself and today's presentation. And I think it should be without saying that fair housing is everything. Feeling safe in your home, being safe in your home. It's for your health, for where your kids go to school, for where you work. It's the foundation for our work. And so, marking the 55th anniversary of the passage of the Fair Housing Act, the landmark civil rights law that made discrimination in housing illegal, is extraordinarily important, and this month gives us that time to do it. The Fair Housing Act, of course, prohibits discrimination in housing based on race, color, national origin, religion, sex, which includes gender identity, sexual orientation, and sexual harassment, disability, and familial status, including pregnancy. And in Illinois, the Illinois Human Rights Act adds an additional 8 additional bases to that. The Human Rights Department has taken a leadership role in passing legislation that expands fair housing protections. There's no greater priority, I believe, in our agency or the Pritzker administration in doing that. The most recent victory, which the governor alluded to, is adding source of income protections for Illinoisans, which could be disability payments or Section 8 vouchers, and it's been a game changer. Our success in advancing this access and fair housing is done with the continued partnership of housing providers, housing advocates, the leaders of the Illinois Assembly, and of course the administration. And I'd have to note that the people from Access Living and the Realtors Association have been a great part of that. We could not have done it without them. This work takes all of us. Together, we can implement policies that recognize our shared humanity and our fight for justice and equality for all, no matter your creed or your color or your identity. We all have people in our lives that have experienced disability. We all know that probably if we're lucky, we're going to have issues with movement as we get older and disability, and we need to feel safe in our houses. We need to have homes that address the concerns that we have, that we can access and enjoy where we live. It truly is a basic human right. Over the next 75 minutes, we're now down to about 70, you'll hear from the Department of Human Rights, the Department of Housing and Urban Development, from our friend and past colleague Lon, the Office of the Attorney General of Illinois, Access Living, and Illinois Realtors, all partners in our work now as well as today. So I'm happy to and excited to hear from them. Their presentations will highlight state and federal disability rights, trending issues that we're experiencing from both housing providers and people that turn to us, and best practices issued in the Reasonable Accommodations and Modifications Guidebook, the one that Victoria just referenced. We would encourage you again to use that QR code that we've all learned to use so much over the last few years to read the guidebook. We really want this to be a powerful tool and a go-to resource for housing providers that'll help them play their part in keeping Illinois housing fair and accessible. Thank you so much. I can't wait to hear what everyone has to say, and I'm happy to pass it back to Victoria.
Thank you, Director Bennett. Let's move on with our program. Today, joining us from Access Living is Ken Walden. Ken will share many reasons as to why reasonable accommodations are important and how they can change somebody's life. Ken, I pass it to you.
Thanks, Victoria. Well, Victoria set the stage. I'm going to spend a few minutes trying to give you some context as to why accommodations and modifications are so critical for folks in the disability community. And I'm going to address three things: affordability, accessibility, and discrimination, which we often describe as the three major barriers for people with disabilities to overcome to attain and retain housing. So let me talk about each one of those in turn. So affordability. Hopefully many are aware that there's been for years and currently is an affordable housing crisis. There's just not enough affordable housing for people of low incomes. And this hits people with disabilities particularly hard because people with disabilities live in poverty at twice the rate of people without disabilities. And people with disabilities haven't been employed historically at less than half the rate of people without disabilities. So it's especially hard for folks with disabilities to afford housing. Because so many are unemployed, they often rely on supplemental security income, which is known as SSI, which is a relief program of the federal government that provides kind of fixed income, very modest fixed income for people with long-term and significant disabilities. But unfortunately, across the nation, there's really no exception to this, SSI is grossly insufficient to cover housing costs. For example, in the Chicago metropolitan region, average one-bedroom units are 149% of the SSI benefit level. Let me repeat that. SSI provides one-bedroom rents are 149% of the SSI level. So if you just simply do the math, you can realize that SSI is normally not going to be enough for a person with a disability to afford your average one-bedroom apartment in Chicago. So affordability is a major barrier. The second barrier is accessibility. HUD did a study several years ago based on the census and determined that less than 5% of the nation's housing stock is accessible to folks with moderate disabilities, and worse, less than 1% is accessible to people who use wheelchairs. So you combine affordability and accessibility, and it's really kind of a toxic mix. It makes it very difficult for someone with a physical disability to find housing because so little of housing is accessible, and so little of housing is affordable. Compounding the accessibility problem is this: accessible housing tends to be consistently more expensive than inaccessible housing. Again, accessible housing is typically more expensive. In 2017, the University of Chicago conducted a study of the Housing Choice Voucher Program and learned, among other things, that wheelchair accessible units are far more expensive than inaccessible units. And then the last barrier added to affordability and accessibility is discrimination. HUD has conducted a couple studies over the last 15, 20 years, both of which confirm that folks who use wheelchairs and folks who are deaf or hard of hearing experience discrimination at various stages of their housing search process. But also the highest percentage of complaints filed by people with HUD and with IDHR which allege discrimination in housing concern disability. Again, more than half of the complaints filed with HUD and more than half of the complaints filed with IDHR concern disability discrimination. So you add those three issues, you kind of combine those three issues together: affordability, very little affordable housing, very little accessible housing, and the incidence of discrimination. It makes it very, very hard for a person with a disability to obtain housing. And when people with disabilities don't obtain housing, they wind up in institutions, they wind up in inappropriate, inaccessible units that they struggle to live in, they get doubled up with family, or worse, they wind up on the street. So returning to the question of why this is so important, this training and accommodations or modifications are important, is because accommodations and modifications can literally make the difference between someone being able to attain and maintain housing or wind up in an institution or homeless. So that's the context for why this is so important, and I will turn it now back to Victoria.
Thank you, Ken. Let me turn my camera back on. But the context you provided humanizes this topic, and I think it's important that we, as allies, show people with disabilities that we hear them, we see them, we stand with them, and we're willing to support them as they ask for reasonable accommodations and modifications. This leads us to our next presenter, my colleague and friend, Stephen Monroy. He is the Director of Fair Housing at IDHR. Today, he will explore the role of our agency and how we protect Illinoisans' rights by outlining the basics of fair housing and discussing the enforcement process. Take it away, Stephen.
Thank you, Victoria, and thank you for coordinating this wonderful presentation with our colleagues. I'd also like to thank Director Bennett and Deputy Director Bautista for their leadership in our department and ensuring that that our fair housing program is set for years to come, and ensuring that we have access to fair housing in Illinois. I'm here today to begin discussing the specifics about disability discrimination and how it fits into the Human Rights Act and the enforcement mechanisms of the Illinois Department of Human Rights. Next slide, please. Thank you. So the Illinois Department of, one slide back, please. Thank you. As Victoria mentioned, I'm the director of the Fair Housing Program at the Illinois Department of Human Rights. Our department is charged with investigating violations of discrimination under the Illinois Human Rights Act. As Victoria mentioned at the beginning of the presentation, we do cover discrimination in a few different key areas. Today, we're specifically talking about housing. However, I do want to note that housing has enormous crossover with other areas of law and discrimination. So a person may experience discrimination or may be charged with discrimination if in one of those areas of housing. However, it could also involve the laws governing public accommodations, such as the more public areas, so common areas, areas outside of a building, as well as could involve areas of financial credit. So we're thinking of mortgage loans and that sort of issues. And then also, it is not uncommon that employment could also have a condition of housing that comes along with it as well. And of course, housing is not just residential units or apartments. Housing can also include dormitories, other kinds of living situations. The key is that this is where a person lives, and these protections apply specifically kind of to the arrangement of housing and less to the exact type of real estate transaction. In addition to enforcing the housing protections, our department also conducts outreach and education, educating the public in forums such as this about what the housing rights and expectations are. Next slide, please. So fair housing is the right for all individuals to choose where to live, regardless of specific factors in the protected classes. So the Illinois Human Rights Act protects almost 20 protected characteristics, including among those disability. So we know that with a condition, where somebody has a disability that they live with, there may be additional need to make adjustments to housing policies or modifications to the premises so that the person can have an equal enjoyment of the property. So the fair housing is that right for people to live where they choose without regard to those protected bases that are protected under the Illinois Human Rights Act and under federal law. Next slide, please. So today I'm specifically speaking of the Illinois Human Rights Act and the Department of Human Rights, but it is an honor to be joined today by representatives of the U.S. Department of Housing and Urban Development, who covers a substantially equivalent law in federal law to our state law called the Federal Fair Housing Act, as well as there's other federal laws and state laws that affect disability that our colleagues from the Attorney General's office will be discussing. And I do want to mention that the information here, although it is focused on state and federal law, there is numerous county and municipal ordinances that add additional protections. So if you, depending on the area that you reside on, please make sure to see if there are other regulations that affect you as well. Next slide, please. Next slide, please. So the basics of disability discrimination are that housing providers may not take these adverse actions against a person or have an effect of a person because of their disability. Some examples of these are refusing to rent or refusing to sell to a person because they have a disability, or based on other factors that impact their disability. Same with people who are current tenants, bringing eviction action because somebody files a request for a reasonable modification would be unlawful, as well as denying tenants the ability to use areas outside of their personal dwelling, so areas that are common areas or recreational facilities. So we might see things like this in condominiums, where in addition to the person's individual unit, they do have a right to accessibility throughout the building. And it is also generally unlawful to set aside specific areas only for people with disabilities to segregate them. So the key in all of these is that individuals must be treated equally, regardless of their specific disabilities. If a person has a disability, they may have a right to a reasonable accommodation or a reasonable modification if it's necessary for their full use and enjoyment of the premises. And all of these are highly individualized factors. And so the key is, what is the barrier that is impacting the person with the disability, and how can it be overcome with that accommodation or modification. And throughout the process, there is a joint interactive process in order to assess what is the disability-related need and what is the requested accommodation and modification request. And you'll hear later on the specifics of how these work in regard to the state and federal laws throughout the presentation. Next slide, please. So a reasonable modification is a change to a policy or a practice of the housing provider in order to ensure that the person with a disability has an equal opportunity to use and access, regardless of whether that's the unit or a common area. So the request for accommodation, in order to have a right to have it granted, it must be both reasonable and necessary. So these are two factors of saying that, what is the relation to the disability-related need, and how does this help overcome some of those barriers of the disability? Now, with reasonable accommodations under state law, the housing provider is generally responsible for the cost of a reasonable accommodation. And examples of these might be waiving a general no animals policy if it's a no pets policy, but there is a request to use an assistance animal that provides a specific need to help overcome some aspects of that disability. So that's an example of a reasonable accommodation request. Next slide, please. The other parts of these requests are reasonable modifications. Now, a reasonable modification involves a structural change to the dwelling or to the area around it. Examples of these include ramps, door frames widening. You'll hear later on in the presentation as well some basics of design and construction standards that have to be included, but reasonable modifications can apply at any time in the process. So saying that even though the dwelling may meet the basic requirements of design and construction, for example, under the Americans with Disability Act, this specific person has a need for an additional change. And it's very key, as you heard Ken say earlier, because accessibility is an incredible barrier to housing, and many units just have not been yet been modified to allow some of that ability to have these additional adjustments. The request for modification must also be reasonable and necessary, and modifications can be made at any time in the tenancy. One exception under federal law, under state law, generally the tenant is responsible for bearing the cost of those modifications, but there is an exception to that where under federal law, the housing provider may have a separate legal requirement to pay for that. So there are some differences between the state and the federal law, but the experience of the housing provider is that they need to comply with both. And under different circumstances, there may be different requirements under these laws. Next slide, please. Reasonable and necessary is a key of deciding whether this accommodation needs to be granted. A request is not reasonable if it imposes an undue financial or administrative burden on the housing provider, or if it fundamentally changes the basic operations of why they're there and providing those services. And a request is necessary if there is that nexus, that connection between the disability-related need to the accommodation and why exactly is it needed in order to ensure equal access to the dwelling. Next slide, please. So as you have heard throughout the presentation, we do have this guidebook on reasonable accommodations and modifications. Many thanks to the folks at Access Living, including Ken, for their support and their co-authorship of this document. So we are excited to be able to share this document, which has been circulating for a few years, in an even more accessible format on our website. So please, again, scan the QR code or visit our website to learn more about this document. Next slide, please. In terms of investigations, as Victoria mentioned at the beginning of the presentation, that is why the Illinois Department of Human Rights is here for. We're here for both investigating complaints of housing discrimination, but we're also here to educate the public in order to proactively prevent discrimination before it could occur. If a person does experience discrimination, they can bring a complaint with us at the department within 1 year. We also receive complaints that are referred from HUD. If a person goes to the federal level first, we also generally receive those in turn. Those complaints, after they are initiated, the department investigates to see if there's substantial evidence of discrimination before it can go on to the next stage of adjudication at the Illinois Human Rights Commission. So if there is substantial evidence, our attorneys will assist in bringing a claim in the Human Rights Commission. And if there's not, then the person will get a notice of why the case was not found substantial evidence. Next slide, please. This is our contact information. And again, please do visit us on our website. And we do have a contact us form so that you can make sure that you are we can route your question, your comment to the appropriate individuals of the department. So please see our website to learn more about the Illinois Department of Human Rights and your rights under the fair housing laws, as well as employment and the many other areas that we cover. Thank you so much, everyone, for your time.
Thank you, Stephen. Those were all valuable insights, and I hope housing providers watching this broadcast will reach out to you in the future for training. And now I would like to introduce Lon Meltonson from the U.S. Department of Housing and Urban Development. He is the Regional Director for the Office of Fair Housing and Equal Opportunity. Today, Lon will cover general information on assistance animals and on how how reasonable accommodations applies to HUD-funded providers. Lon, the floor is yours.
Thank you very much, Victoria. As I wait for my PowerPoint to come up, again, my name is Lon Meltonson, and I'm the Regional Director for the Office of Fair Housing and Equal Opportunity here in Region 5 in HUD. And I would like to give my thanks to the Illinois Department of Human Rights for both putting on this webinar today and for inviting me to be able to participate on this very important topic. So what I would like to do today is to give everyone a brief overview of assistance animals under the Fair Housing Act, and then talk just a little bit about Section 504 of the Rehabilitation Act of 1973. Now, in my short amount of time, unfortunately, I cannot go into great detail on either of these two topics. So my goal is to provide you with a general overview to improve your understanding of both of these two areas. But at the end of my presentation, I will have a slide which contains resource information for everyone in the audience, so they can go to those sites on HUD's website and to obtain much more detailed information on these two topics. Next slide, please. So I want to start with talking a little bit about assistance animals under the Fair Housing Act. And this is a topic I think is very relevant because at the beginning, Ken mentioned the fact that disability complaints are the #1 complaints that are filed both at HUD as well as with our state partners across the country. And of those disability complaints, the majority of them involve failure to grant a reasonable accommodation. And if you were to break down those reasonable accommodation cases, you will see that the majority of those cases involve requests for accommodations for assistance animals. So I want to start off my discussion with just giving you a better understanding of what is an assistance animal under the Fair Housing Act. So under the Fair Housing Act, an assistant animal is either a service animal or an animal that is trained or untrained to do work or to perform tasks or to provide assistance or to provide therapeutic emotional support for individuals with disabilities. So this is a very broad definition. It's much broader than under some of the other state and federal laws. And my colleague from the Illinois Attorney General's office who will be following me will be talking a little bit more in detail in terms of the differences between service animals under some laws and assistance animals under the Fair Housing Act. Next slide, please. So one important point I want to get across where there tends to be some confusion is that assistance animals are not pets. So a housing provider may not charge a pet fee or a pet deposit for an animal that is an assistance animal under the Fair Housing Act. Additionally, if a housing provider allows pets or has pet rules, those rules should not be applied to assistance animals. And a housing provider cannot restrict the size or the breed of an assistance animal. Now, a housing provider can charge a tenant for damages that an assistance animal causes if it is the housing provider's usual practice to charge for damage caused by tenants. Now, the person who is requesting or needs the accommodation is responsible for feeding, maintaining, providing veterinary care, and controlling the animal. The individual may do this on his or her own, or with the assistance of a family member, a friend, a volunteer, or another service provider. Next slide, please. Now, another issue that tends to come up in this area is relating to the nature of the animal itself. So one of the things I want to talk a little bit about are what are the distinctions between requests for an assistance animal, which is an animal that's typically kept in a household, versus a request for an assistance animal that's what I'm going to call a unique animal. So if the requested assistance animal is for an animal that is commonly kept in households, the person requesting the animal does not need to demonstrate a disability-related therapeutic need for that specific animal or that specific type of animal. So animals that are commonly kept in households would include dogs, cats, small birds, rabbits, hamsters, gerbils, fish, turtles, or other small domesticated animals that are traditionally kept in a home for pleasure versus a commercial purpose. However, if the requested animal is for a unique animal, such as one that's not commonly kept in households, such as a barnyard animal, a monkey, or a non-domesticated animal, the person requesting the accommodation has the added burden of demonstrating that there is a disability-related therapeutic need for that specific animal or specific type of animal. Next slide, please. So now I want to talk just a little bit about how a housing provider should respond to a request for an assistance animal. Well, the first thing you should be aware of is that the same principles for reasonable accommodations applies to requests for an assistance animal. So a housing provider should respond to a request for an assistance animal just like they would any other request for an accommodation. So a request for an accommodation for an assistance animal can be made orally, or it could be made in writing as well. The request may be made by the person themselves who need the accommodation or by another on behalf of that individual. And another thing to keep in mind is that a request for reasonable accommodation can be made either before or after the assistance animal is acquired, and a request for reasonable accommodation can be made at any time, even after a housing provider seeks to terminate the tenancy because of the existence of the animal. Although I will point out that the timing may create an inference against good faith. And then lastly, an individual requesting an accommodation for an assistance animal doesn't have to use specific magic words such as reasonable accommodation or assistance animal. Next slide, please. So what are the criteria for granting an accommodation for an assistance animal? Well, the first criteria is, does the person needing the assistance animal have a disability? So if the person has an observable disability, or if the housing provider already has information giving them reason to believe that the person has a disability, this criteria has been met, and the housing provider should not be requesting additional information as to this criteria. However, if the person doesn't have an observable disability, or the housing provider does not already have information giving them reason to believe that the person has a disability, the person requesting an accommodation should provide information that reasonably supports that they have a disability. If the person has provided this information, this criteria would be met, and the housing provider should not be requesting any further additional information. However, if the person has not provided this information, the housing provider should provide the requester the opportunity to provide such information before denying the accommodation. And as a side note, I just want to stress that the housing provider is not entitled to know an individual's diagnosis. Next slide, please. So the next criteria is there a disability-related need for an assistance animal? So under this criteria, if the person has provided information which reasonably supports that the work the animal does, or the task that the animal performs, or the assistance that it provides, or the emotional support that it provides, this criteria would generally be considered met and no further information should be requested. However, if the person has not provided this information, the housing provider should provide the requester with an opportunity to provide such information before denying the accommodation. Next slide, please. So now I just want to spend a minute or two talking a little bit about what type of information would be sufficient to constitute a disability or to confirm a disability-related need for an assistance animal. So proof of a disability can be established from a federal, state, or local government agency's determination of disability, or from receipt of disability benefits or services, or eligibility for housing assistance or a housing voucher received because of a disability, or information confirming disability from a healthcare professional, such as a physician, optometrist, psychiatrist, psychologist, physician's assistant, nurse practitioner, or nurse. Similarly, reasonable supporting information confirming a disability-related need for the assistance animal often consists of information from a licensed healthcare professional, such as the one I've previously identified, that is general to the condition, but specific to the person, which explains the relationship or connection between the disability and the need for an assistance animal. Next slide, please. So on HUD's website, we have a toolkit that's available for housing providers to help them kind of navigate these requests for accommodations for assistance animals. And the link to this is on one of my slides coming up, but I just wanted to just highlight for a second the information that's available on our website. So if you go to our website, you can download a fact sheet, which provides a lot of information and answers a number of questions related to assistance animal. There is also a webinar on the topic of assistance animals that goes into much more detail than I can do in the 15 minutes I have here today. So I would encourage you to watch the webinar. And there's also an interactive tool which is designed to help walk a housing provider through the decision-making process in determining whether a request for a reasonable accommodation should be granted or not. And then also available on the website is a link to HUD's FHEO guidance from 2020 on assistance animals, and that could also be downloaded directly from this site. Next slide, please. So in the few minutes that I have remaining, I just want to give a very broad overview of Section 504 of the Rehabilitation Act of 1973. So what is Section 504? So Section 504 of the Rehabilitation Act is a federal law which is codified at 29 U.S.C. 794, which prohibits discrimination on the basis of disability in federally assisted programs or activities. HUD's regulations on 504 can be found on our website or at 24 CFR Part 8. Next slide, please. So who does Section 504 apply to? Well, Section 504 applies to any state or its political subdivisions, any instrumentality of a state or its political subdivisions, any public or private agency, institution, organization, or any other entity or person to which federal financial assistance is extended for any program or activity directly or through another recipient. And so I want to focus a little bit on that last part of that sentence there. So 504 is going to apply to any one of these entities that directly receive funding, federal funding from the government, federal government, or as a subrecipient of such funding. So for example, if HUD were to grant funding to a state entity, and then that state entity makes that funding available to a recipient, the recipient who accepts that funding is a subrecipient of the federal funding and is therefore going to be covered by Section 504. Now, a question that often comes up is whether a private landlord who accepts a Section 8 tenant-based voucher is covered by Section 504. And so the answer to that question is no, that a private landlord who accepts Section 8 tenant-based voucher as a payment for rent is not a recipient of federal financial assistance merely by virtue of receiving such payments. However, the housing authority who issues the Section 8 voucher as part of its Section 8 voucher program or activity will be covered by Section 504. Next slide, please. So what does Section 504 prohibit? So Section 504 prohibits discrimination on the basis of disability in any program or activity that receives federal financial assistance. This includes denial of the opportunity to participate in a program or activity because of the person's disability, or the placement in a different or lesser program or service. Next slide, please. So what does Section 504 require? Well, Section 504 requires that persons with disabilities are given the same access to programs and services as persons without disabilities. And so this could include the obligation for the housing provider to grant reasonable accommodations to both policies and physical modifications to the property. And so this is one area where Section 504 differs from the Fair Housing Act. So as Steve had mentioned earlier in his presentation, if there is a request for a modification under the Fair Housing Act, the burden of paying for that modification is on the tenant or the person requesting the modification. However, the same is not true under Section 504. Under 504, it treats modifications the same as reasonable accommodations. So that if there's a request for a modification, that the burden is going to be on the housing provider to provide that modification. Next slide, please. So on my final slide here, I have the links to the HUD's website. So the first is for our toolkit on assistance animals. So if you go to that link there, you'll be able to access all the information which I showed you on my previous slide regarding assistance animals. And then I've also provided a link to information that we have available on Section 504. So with that, I see my time is up. So I will now turn it back to Victoria. Thank you.
Thank you, Lon. Here, I'm coming back on. I learned so much about assistance animals, and my team will add links to the resources you mentioned in the comments section below. Moving on, now I would like to introduce Judith Levitan from the Office of the Attorney General of Illinois. Judith is the Disability Rights Chief, and she will be outlining how the Americans with Disability Act, ADA, applies to residential areas, and she will identify ways housing providers can handle any accommodation requests. Judith, you're up.
Hello, everyone. I am Judith Levitan, Bureau Chief of the Disability Rights Bureau of the Illinois Attorney General's Office. Today, I will speak about the role of the Attorney General's Office in advancing the rights of individuals with disabilities in all aspects of society, including housing.
She's frozen.
I will focus on the specific disability protections that apply to public and common use areas of residential facilities. So let's get started. First, let me tell you a little about the Disability Rights Bureau. What does the Disability Rights Bureau do? The mission of the Disability Rights Bureau is to protect and advance the rights of individuals with disabilities in Illinois. The Rights Bureau do. The Rights Bureau do. The mission of the Disability Rights Bureau is to protect and advance the rights of individuals with disabilities in Illinois to equal access to all aspects of society. How do we work to accomplish this mission? We utilize a three-pronged approach. The first prong is enforcement. We enforce state and local laws that protect the rights of individuals with disabilities. We receive complaints and resolve them through investigation, negotiation, and when necessary, litigation. The second prong involves providing technical assistance. We staff 2 technical assistance phone lines, one in Chicago and one in Springfield. We provide information, education, and trainings to our constituents with disabilities and others across the state that seek to comply with disability rights laws. And the third prong involves policy. We work to shape policy by participating on relevant committees, proposing and commenting on legislation, and working with other state attorneys general to advocate for our constituents with disabilities on a national level. Next slide, please. Now that you know what the Disability Rights Bureau does do, let's clarify what the Disability Rights Bureau does not do. The Disability Rights Bureau does not have the authority or jurisdiction to represent individuals as their personal attorney or obtain money damages or other personal relief for individuals. Individuals with disabilities who are seeking personal relief can file complaints with the Illinois Department of Human Rights. The Disability Rights Bureau will investigate a complaint when there is reasonable cause to believe that a person or group of persons is engaged in a pattern or practice of discrimination or is applying discriminatory policies. You can find more information about the work of our Bureau online at the link provided on this slide. Next slide, please. Stephen and Lon have already discussed the legal rights afforded to individuals with disabilities under the Human Rights Act and the Fair Housing Act. I am going to focus now on the disability rights laws that apply to the public and common use areas of residential facilities. The Americans with Disabilities Act, or ADA, generally does not apply to housing. However, it can apply to areas of residential facilities that are open to the public, such as rental offices, sales offices, parking lots, community meeting rooms, clubhouses, pools, basically any area of a residential facility that may be open or made available to non-resident members of the public. Title II of the Americans with Disabilities Act applies to housing when it is provided by a state or local government, such as public housing or university housing at a state university. Title III of the Americans with Disabilities Act, as well as Article 5 of the Human Rights Act, apply to what we call places of public accommodation. Places of public accommodation can be described as privately owned businesses and facilities that are open to the public. Finally, the architectural or physical accessibility requirements of public places are governed by the ADA Standards for Accessible Design and the Illinois Environmental Barriers Act and its implementing accessibility code. So if you are building or altering any public spaces in your residential facility, you need to be aware of the existence of these architectural requirements. Next slide, please. Just as HUD and IDHR receive a large number of calls and complaints regarding assistance animals in housing, which are covered by fair housing laws, my office receives a large number of calls and complaints concerning service animals, which are covered by the ADA and certain state laws. There is often confusion regarding which laws apply in residential settings. So let's compare and contrast. The Americans with Disabilities Act defines a service animal as any dog individually trained to do work or perform tasks for the benefit of a person with a disability. Miniature horses must also be allowed if they are specifically trained. Compare that to the definition of assistance animal that Lon previously provided and which I have copied here for your convenience. First, you will notice that assistance animals refers to a broader category of animals that includes service animals, as well as emotional support animals and untrained animals that provide a benefit. You will also notice that under the ADA, service animals are limited to dogs and sometimes miniature horses, whereas under fair housing laws, assistance animals are not limited to dogs or any particular species of animal. So, if a prospective tenant comes into your rental office with an emotional support cat, that individual would not be protected by the ADA, which covers rental offices, since the ADA only recognizes dogs as service animals. However, that prospective tenant might have a right under fair housing laws to have that emotional support cat live in their dwelling as a reasonable accommodation, even if the housing does not typically allow pets. You can see how this can get very confusing. Next slide, please. Let's continue to compare and contrast. What does the law require? Under the ADA, service animals must be permitted to accompany a person with a disability wherever members of the public are allowed to go. In Illinois, service animals in training are also permitted to accompany the trainer wherever the public is allowed to go. By comparison, under fair housing laws, housing providers must consider requests to keep an assistance animal in housing as a reasonable accommodation that may be necessary for a person with a disability to have an equal opportunity to use and enjoy a dwelling, including public and common use spaces. Next slide, please. The setting in which an individual with a disability wishes to bring an animal will determine the information you can ask the individual about their animal. So, what inquiries are permissible? Under the ADA, public accommodations can ask only 2 questions to determine if an animal is a service animal. 1, is this animal needed because of a disability? And 2, what work or task is the animal individually trained to perform? You cannot ask the nature of the individual's disability. You cannot ask the animal to demonstrate the task. And you cannot ask for training or certification papers. It is perfectly appropriate for an individual with a disability to train their own service animal. It is not appropriate to ask either one of these questions if the answer is apparent. Compare that to fair housing laws, which require housing providers to evaluate a request to keep an assistance animal in a dwelling as a reasonable accommodation request. Housing providers may ask individuals whose disabilities are not readily apparent or known to the provider to submit reliable documentation from a medical professional showing that the person seeking to use and live with the animal has a disability and that the person making the request has a disability-related need for the assistance animal. So while it may be appropriate for a housing provider to ask for medical documentation from a tenant wishing to keep a service dog in their dwelling as a reasonable accommodation, it would violate the ADA to ask for such documentation from a prospective tenant who comes into the rental office with their service animal seeking to fill out a lease application. Next slide, please. Let's continue to compare and contrast. Under the ADA, a public accommodation may ask an individual with a disability to remove a service animal in several limited circumstances. A service animal can be excluded when the animal is out of control and the handler does not take effective action to control it, the animal is not housebroken, or that particular animal is a direct threat to safety. It's important to remember that even when it's appropriate to exclude a service animal, it is not appropriate to exclude the owner. The individual with a disability must still be offered the opportunity to obtain the goods and services of the entity in some other way. Housing providers may also deny a request for an assistance animal as an accommodation under certain circumstances, following the typical procedures for evaluating reasonable accommodation requests in housing. Lon very thoroughly went over these circumstances earlier, so I have just provided a summary on this page for the purpose of comparison. Next slide. For more information on service animals and assistance animals, follow the links provided to see the brochures published by the Office of the Illinois Attorney General on these topics. Next slide, please. Now, we will discuss the laws that govern architectural or physical accessibility requirements in the public use areas of residential facilities. The Environmental Barriers Act requires that every public facility in Illinois constructed or altered on or after May 1st, 1988, comply with the minimum accessibility requirements set forth in the Illinois Accessibility Code. Title III of the Americans with Disabilities Act requires that every place of public accommodation constructed or altered on or after January 26, 1992, meet the minimum accessibility requirements contained in the ADA standards for accessible design. In addition, the ADA requires that any facility that was constructed before its effective date remove barriers to access to the extent that is readily achievable. Whether barrier removal is readily achievable is determined on a case-by-case basis. It is important to be aware that these regulations exist if you plan to build or alter any public areas of your residential facilities. Next slide, please. Also be aware that our state accessibility code says that common use as well as public use spaces in multi-story housing must comply with the technical requirements of the IEC. Multi-story housing is defined as a building of 4 or more stories containing 10 or more dwelling units. Common use areas are defined as spaces that are held out for use by all tenants and owners in multi-story housing and would include areas such as lobbies, elevators, hallways, laundry rooms, recreation areas, and other areas that are used by all residents. Next slide, please. Let's talk about accessible parking. Our Bureau receives a lot of complaints and a lot of questions regarding accessible parking. There seems to be confusion about what is required in residential parking lots. The Illinois Accessibility Code states that where off-street parking spaces are provided for the public, for visitors, or for employees, accessible parking spaces must be provided in accordance with this chart. You can see that the number of accessible parking spaces required depends on the total number of parking spaces provided. So, unless the parking that serves a residential facility is restricted to resident parking only, that parking facility is subject to the Illinois Accessibility Code. Next slide. We find that there is often confusion between the accessible parking spaces a housing provider must provide under the Illinois Accessibility Code and the parking spaces a housing provider may have to provide as a reasonable accommodation under the Human Rights Act and Fair Housing Act. Let's compare and contrast. Under the IAC, when parking is provided to the public, visitors, or employees, residential parking areas must provide accessible parking spaces that comply with regulations governing number, size, striping, markings, signage, and location. Under the Human Rights Act and Fair Housing Act, a resident with disabilities may request an assigned parking space and/or an accessible parking space as a reasonable accommodation, even in resident-only lots. Housing providers must evaluate a resident's request for an assigned parking space using the general principles applicable to all reasonable accommodation requests. An accessible space that is assigned to a resident as a reasonable accommodation cannot count towards the full count of accessible parking spaces required in parking areas that are also subject to the IAC. So remember, if your residential parking lot is open to the public, visitors, or employees, then it is subject to the technical requirements of the IAC as well as to the reasonable accommodation requirements of the Human Rights and Fair Housing Acts. Next slide, please. For more information on the technical requirements for accessible parking, follow the link provided on this slide to see the brochure published by the Office of the Illinois Attorney General. I have also provided links to the Illinois Accessibility Code and the ADA standards for accessible design. Next slide, please. That concludes my portion of today's presentation. I thank you for your time. Feel free to contact the Disability Rights Bureau of the Illinois Attorney General's Office if you have any questions. Our contact information is provided on this last slide. Have a nice day, and now I'll turn it back to Victoria.
Thank you, Judith. Sorry, I'm not sure exactly what happened here with my screen. I had to switch out computers because my iPad died halfway. But anyway, that presentation was incredible. And now it's my pleasure to introduce Betsy Urbance with Illinois Realtors. She is the General Counsel and VP of Legal Services. Betsy will cover educational resources and address how disability rights are integral to the real estate industry. Betsy, take it away.
Thanks very much, Victoria. And thanks to everyone for inviting us to the table. I represent Illinois Realtors as its general counsel, as Victoria said, and we are thrilled to be included in this esteemed group of regulators. So we really do appreciate the opportunity to join this session today. My focus will be, I'm going to provide some additional resources for those folks that are in the industry. And when I say industry, I'm talking to housing providers that are owners, that are landlords, that are real estate brokers, property managers, and all of those folks that belong to our association so that they're realtors as well. So not only did all of the regulation that my esteemed colleagues just covered, but there's some additional regulation. So with that, why don't we go to the resource slide? So of the resources, we through our member service that is a legal hotline get questions all the time about assistance animals, service animals, therapeutic animals, you name it, it's a hot topic. So of course the resource, I think it's it's one of the ones that Lon included. It's the federal statement. It's dated like January 1, 2020, that provides a decision tree for housing providers to go through if someone approaches them about a need for a service or assistance animal. In addition, this guidebook that's just been redone that Stephen discussed is an absolute essential requirement for anyone that provides housing. It's really, really a good tool. And I thought Judith's presentation and the comparing and the contrasting how ADA and fair housing coincide, how they differ, and how they might apply to housing providers depending on the situation. From our standpoint, from the industry standpoint, there are some additional resources that might help you. Illinois Real Estate License Act, those folks that are licensed as real estate brokers and that provide third-party property management service, they should be intimately familiar with Section 20, which requires, along with everything else, the federal, state, the local fair housing laws, their license law also applies and requires compliance with fair housing, especially in the case of folks that are in protected classes and those with disabilities seeking housing. The administrative rules under the License Act further clarify and actually have very specific provisions that require brokerage agreements or property management agreements to include language that comes right out of the Illinois Human Rights Act, referring to all the protected classes in Illinois. Additionally, Illinois Realtors offers courses that if you're a broker, you can take the courses. If you're a housing provider, there's nothing that would prohibit you from taking courses, even if you don't have a continuing education requirement. One of those courses is a 3 or 4 hour session. It's Fair Housing 302. It's available on our website that you'll have later, that deals with assistance animals and fair housing. Another just overview of just providing access to everyone as you find them is a video entitled Bias Override: Overcoming Barriers to Fair Housing. That is also embodied in another course, Fair Housing 312, which is given periodically. I think we have an education provider that will provide this course at our spring conference in May, but check out our website and that resource is also available. The National Association of Realtors, those folks who belong, they're housing providers, they're licensed, they belong to the Realtor Association, they bind themselves to a very strict code of ethics. Indeed, Article 10 is all about providing fair housing, and that applies not only to the practice of the individual, but also to their lives, how they behave, essentially. And they bind themselves to a provision in this code of ethics that says, look, I will provide fair housing to all, and I won't even display a propensity to discriminate. The NAR, the National Association of Realtors, also has a primer on disability, very short, broad overview. And what I found very interesting is the NAR article about universal design concepts, which I'll talk about in a little bit more detail later. The other link that we're providing for you is the WCAG, the Website Content Accessibility Guidelines link. This is important for everyone who wants to find housing providers or anything on the web for that matter, but it provides guidelines. These guidelines, this is really a technical site, but it would be for anyone on your IT team or that you consult with on your website, and how people can access your website. So now let's get into some practical discussion about how we can increase housing for everyone, including those with disabilities. So just as a practical matter, speaking to housing providers, I would encourage that the housing provider, that y'all be proactive as opposed to reactive. In other words, educate yourself. Check out that guidance book that IDHR produced. Check out that HUD guidance. And another really practical piece of advice, I think, or suggestion is seek out groups, find groups of, let's say you want to be more proactive with helping the deaf community, or with helping the vision impaired community, or those folks that need wheelchairs or assistance to move about. Find those groups. Those are the people, those are your market. Those are the people that need housing, and you can learn what they need in their housing. And as noted before by almost everyone, there's a huge shortage of affordable and accessible housing. So that's what we advocate for all day, every day. So we're working on those matters for all. Assess how, first of all, how do people that need your services find your services? So of course, the advertising, TV, radio, social media, the website. As I just talked about, how does my website appear to someone, to everyone? Is my website accessible? Can they find my services? Can they find the housing I'm providing? If I have a problem seeing, can I hear what's happening on your website? If I can't see, or is there a closed caption option? Or excuse me, if I can't hear. If I have trouble navigating a mouse, are there keyboard options that I can use to access your services through your website? So those are, how do people find you? Next slide. Now the question is, your physical property. Expand the market if you can, if you're a housing provider and you can expand your market for all. Going back to the suggestion about being proactive, how about if you're a housing provider, a property manager, analyze the physical nature of the properties. Are the properties that you manage for the folks you're providing housing for, are they accessible? How do you get in? Just some of these practical might the lighting be better? Might grab bars be installed easily if these are requested? If there are stairs and no elevator, is there a way that a stair lift could be installed? These are things that the housing provider can ask themselves prior to being asked. So when you meet the person who needs the accommodation or the modification, you can respond to them in an expeditious manner. Do you have policies regarding reasonable accommodations or modification requests? Now, there's no legal requirement that you have policies, but we find in our business that the more we have policies and the more we anticipate the questions or the needs, the better we are at reacting and providing answers and responses for those needs. In this case, do we need to change a rule or a policy? Do we need to make a physical modification to the property to assist a person who needs housing? Do you have policies in place for accepting assistance animals? This is a humongous question, and we get this question at our office all day, every day, from our housing providers, our property managers, our landlords, our brokers, assisting people that need the housing and need accommodations for the assistance animal. Have you considered, if you are remodeling or perhaps you're thinking of building, you're a developer and you're going to look into workforce or affordable or accessible housing, have you considered maybe in the remodeling, sometimes you're going to be legally required in the remodeling, as Judith discussed, but if you are making changes to your building, if you're repurposing spaces, are there ways that you can incorporate universal design concepts if you're building new or remodeling before you've even been asked? So that's a possibility, that you start thinking in those terms and expanding your market for all. I think, do I have any other slides? So I don't really think I have any other slides, but I just want to, again, thank everybody for the opportunity to be here and to take part in this really, really important discussion. And thank you.
Thank you, Betsy. I loved your suggestion about being proactive instead of reactive. Any of the resources you provided have been incredibly helpful for housing providers, and they are all listed in the comments section of our stream. At this point, I want to mention that if we missed any resources, you will see them coming in the comments section as well. If you see something that interests you, please give it a thumbs up. This would allow our stream to grow and so that more people can hear this valuable message. And finally, it's time for us to get to the Q&A section of our program. I know we have a couple of questions and we only have time for, I believe, 3 or 4, but we're going to go in speaking order. If everyone who, thank you. If the presenters can come back on screen, we're going to start highlighting these questions. Perfect, thank you. This question is for you, Stephen. Who is considered a housing provider under the Illinois Human Rights Act? Can you provide examples?
Yes, thank you, Victoria, for the question. So who is a provider under the Illinois Human Rights Act is a pretty broad category. And so it depends on what they're doing and how they're involved. The key is how is it related to the real estate transaction? So this can include landlords, owners, could also include their agents. So real estate agents, brokers, the banks that provide mortgage loans. So it is very broad category of who may be a housing provider. And I should mention as well, this can be both private entities and it can also be government entities as well that could be covered under the both Illinois Human Rights Act under the Federal Fair Housing Act.
Thank you, Stephen. Hopefully that clarifies some of the questions that we've seen come through in our chat. And now I believe this question is for Lon. Can a person get documentation supporting their disability-related need for an animal from a telemedicine provider?
Thank you, Victoria, for that question. It's a very relevant question as that comes up frequently. So I'm going to answer that question generally as a yes. A individual can provide documentation from a healthcare provider who has treated them either remotely or through telemedicine. As I had mentioned before, if a disability or disability-related need is not obvious or known to the housing provider, the person does have to provide reasonably reliable documentation to establish the disability or the disability-related need. There are many legitimate licensed healthcare professionals who deliver their services remotely, including over the internet. The reality is telehealth and telemedicine is our future. So just because the services are rendered remotely does not render it on its face unreliable. Now, what I will say is that there are websites out there where individuals can purchase a certificate, registration, or licensing document for an assistance animal to anyone who will answer a few questions or participate in a short interview and pays the fee. So documentation from such websites like that may not be sufficiently reliable to establish a disability or disability-related need. Now, with that being said, I will caution everyone out there that just because someone might have provided their documentation and obtained it from one of these websites where you could go and purchase it does not necessarily mean that the person does not have a disability or there isn't a disability-related need for the animal. I think Ken mentioned in his opening statement that persons with disabilities have a much greater unemployment rate than persons without disabilities, and the income levels for persons with disabilities is far less. And so oftentimes persons with disabilities may not have access to a doctor, and so they may, or it may be too expensive for them, so they may end up going to one of these sites because of their limited financial resources. So just because they obtained it from that doesn't mean that the person's not disabled or not doesn't need the animal. So a best practice would be, if a housing provider is concerned regarding the documentation, they should engage in an interactive process with the individual and explain their concerns regarding the documentation and give the person an opportunity to provide adequate documentation.
Perfect. Thank you so much, Lon. If anyone else has any other questions related to like support animals in particular, we'll put up a QR code so that folks can contact us after the event as well. Judith, I believe this question is for you. Do service animals need to wear identifying attire?
No, service animals are not required to wear any type of identifying attire. They do not need to wear any specific vest or harness that identifies them as being a service animal. Unfortunately, there are a lot of online scammers that try to sell this type of attire to constituents with disabilities, who may then be confused into thinking that their service animals are required to wear this type of identifying attire, but it is not required.
Thank you, Judith. I think that distinction is important, especially when we don't need to specify if different animals have to wear anything that identifies them. And finally, Betsy, this question is for you. If a home is not accessible, might the real estate agent or realtor advocate on behalf of their client for reasonable accommodations or modifications during the negotiation process?
Right. It's my mind. Yeah. Okay. That is a great question. And during my portion, I was targeting my comments mostly to housing providers. But on the other side of things, realtors are licensed real estate brokers. Even if you're not a realtor, if you represent buyers or if you represent tenants that need accessible housing, you absolutely, short of practicing law on their behalf, can advocate on their behalf. My best suggestion for a buyer or tenant representative of a person with a particular disability is, not only do you have kind of your human obligation to your client, but you also have statutory, and if you're a realtor, ethical duties to your client to serve your client's best interests over your own. So you want to have a conversation with your client as to what their needs are. And once you know what your client needs for the housing that they're in search of, based on how you found your client, you want to advocate on their behalf and find properties, find units, find homes that could meet their needs. And if the needs are not met, as in the question, if they're not accessible, is there a way to make it accessible for your particular client by way of a reasonable accommodation or even a modification, whether you're talking purchase or sale? So yes, absolutely.
Thank you. I think that provides a lot of clarity, and it kind of brings everything together especially after these 90+ minutes that we've been talking, it showcases that we all play a part in helping people with disability access accommodations and reasonable modifications. Anyway, I think we've come to the end of our program. I want to close this program by thanking all of the housing providers and stakeholders who are here with us today. There are many resources available to you, and if you need additional support or technical assistance, we are all here for you. In particular, at IDHR, we have a training institute that offers a wide variety of trainings related to the Illinois Human Rights Act. You can view those course offerings and register on our website at dhrillinois.gov/training. I'll repeat that website one more time. It's dhr.illinois.gov/training. And finally, if we didn't get to your questions, I want to reiterate that you will be able to scan this QR code and complete the form so that somebody from my office can get back to you. Thank you so much for being here and for taking the time. It was an incredible learning opportunity, and we hope to have more of these live events and cover different topics in the future. If you have any suggestions on like topics, we're open, we're all ears. Just make sure you leave more details in the comments section. Thank you so much for coming to our live stream. Have a great afternoon.